Good morning. Please
Good morning,
introduce
sir.
yourself without mentioning your name. Please
Sir,
introduce yourself without mentioning the name.
I have qualified sir, I have completed my LLB from Utkal University in the year of 2017, and after that, in 2019, I have started preparing for judiciary, and this is my second attempt.
Okay. And can you tell me why did you choose judiciary only as your career option?
Sir, when I first came to this profession, I started studying all the subjects and kind of I feel excited after knowing all the facts and circumstances where respect is the huge factor, and some one of my relative is in this field, so I opt to choose this career.
Okay. Can you tell me who is the current Chief Justice of our High Court?
Sir, Justice Chandrachud.
Of our High Court, I'm asking.
Oh, sorry, sir. The initials I don't remember, but Justice Chakradhari.
Okay. Okay. Uh, what is the evidentiary value of an FIR?
Sir, FIR only can be used to contradict the accused only can use for contradiction. FIR is not a substantive piece of evidence, and it is not an encyclopedia also, so it can only be used for contradiction.
Okay. Okay. What is a protest petition?
So protest petition means when the cognizance is taken under section 190 of CRPC, and the final report is given that final report is negative, then the person who is aggrieved or the relatives of the person can also go to the magistrate uh, to apply that more investigation can be done to that offense. So that is called protest petition.
Okay. Uh, what is the difference between primary evidence and secondary evidence?
So primary evidence is the direct evidence, and secondary evidence, when the primary evidence is not available, the secondary evidence is given. Section 65, 63 and 65 of the Indian Evidence Act talks about the secondary evidence, and section, uh, sir, I don't remember the section
It's
of
okay.
primary
You just tell
evidence.
me. You just tell me what does it mean.
Um, uh, when a document, when it is produced before the court, it is a example, a sale deed. When a sale deed is given to the court, that is a primary evidence, but when it is done by a mechanical process, and uh, when it has two copies and one is not attested, one is not signed by the other party, then the first copy is the primary evidence, and the second copy of the first copy is the secondary evidence. If the copies are done in the same process, then all of the copies are primary evidence of each other. But if it is done one is the main copy, and others are of the copies of the first copy, like made in the basis of a photocopy, like a photocopy. But example, a newspaper is the primary evidence, because newspaper, all the papers are done in the same process. Um, that's also.
Can you tell me what do you understand by hadia
Sorry, sir, I'm unable to recall it.
in Muslim law? You have taken personal law, right?
Yes, sir.
Okay. And rad, doctrine of rad.
No, sir, I'm unable to. Um,
Okay. Uh, can you tell me? what is a will and how is it different from codicil?
Sir, will is a legal declaration of the intention of the testator in regard to his properties, how he wanted to give his property after his death. Um, Codicil is the legal. Uh, Rob, I don't know. Codicil will is the legal declaration.
Okay. Who is a child in conflict with law?
Pardon, sir. Network error.
Who is a child in conflict with law?
Child. Unable to answer.
Okay. Can you tell me what is the difference between period of limitation and prescribed period?
So prescribed period of limitation is what is already prescribed in the act, and period of limitation is that what can be extended by the what can be extended. There are
Did you say
exceptions.
period is what prescribed is what is mentioned in the act, or period is what is mentioned in the act?
Confused. Sorry, sir. I'll go through it once again.
Okay. What is a donatio mortis causa?
Donatio mortis causa is known as the deathbed gift. It is defined under Section 129 of the Transfer of Property Act. But the TP Act does not applicable to the Muslims. When the person is on deathbed, when he makes his will, that is called donatio mortis causa.
Right. Mm, give me an example of a cause of action which is both a cause of action for a criminal case and a civil suit.
Sir, public nuisance, it is dealt with also as a civil case, and if there is any criminal activity appears, then it can also be dealt with in dealt as a criminal case. The provisions are like under section 91 of the PV, public nuisance is defined, and section 268 of the Indian Penal Code also defined the punishment for public nuisance, and also CRPC dealt with public nuisance. Sir, I don't recall the section 107, 108. Executive
Okay.
magistrate can take
Okay.
the cognizance.
Okay. Can you tell me uh, you're from which district?
Koraput, sir.
Yes. So can you tell me something about Lakshman Naik?
Sir, he is a freedom fighter. He is from Tentuliguma, which is far from Koraput headquarters. And here, I don't remember the dates, but in his name there is a medical college in our district. Um, he belonged to a tribal community.
What else is Koraput famous for?
Sir, it is famous for our Sabara Sikhetra, the Jagannath temple. It is the temple where the tribal community people have they do the Ratha Yatra here, and like other places where Brahmins dealt with the or deal with all the pujas, here the tribal community do all the things. And also it is the district headquarter. Here we have our SP office, and also the court and medical college. There is also a medical college which is established in 2015.
Okay. Okay. What is Durham rule?
Sir, I'm not able to hear.
Okay.
I'm not able to hear it, sir. Can you repeat the
You're
question?
not able to hear Durham's
Exactly.
rule. Durham rule.
Sir, it is
DUR.
defined under. Okay, so Section 84 of the Indian Penal Code deals with insanity. It has two rules. One is Durham rule and another is McNaughton's rule. According to Durham rule, a person can take the plea of insanity if he has done anything criminal. If he has done any criminal act, then he has to prove that he is under any kind of delusion while doing the act. So he can take the defense of the Section 84 under Indian Penal Code.
Right. Okay. So, what is your view about the reservation policy?
So, in my view, somewhere reservation policy is good, but nowadays, before the independent, sorry, after the independence, there is a huge discrimination among the people, but now it is less. And due to the reservation, many people, many meritorious students who can who who are very capable of doing all the things, but they are not having the opportunity to do this because of this reservation policy. So there should be a cap on it, and it should not be like so I'll have to prepare it and then I'll have.
Okay. Can you tell me whether there is any principle of set off under CRPC?
Yes, sir. It is under Order 8, Rule 6A. Sorry, Rule 6.
CRPC, I'm asking.
Sorry. Sir, I'm unable to recall it. There is, I guess.
Okay. Yes. If a bail is granted by the Sessions Court, which courts can cancel the same?
Sir, it can be cancelled by the High Court and the Sessions Court itself also, and Supreme Court also.
Okay. Okay. Uh, whether res judicata can be used as an evidence, as a plea of evidence.
I'm not sure of it. I'll go through it.
Okay. Whether the statements that are contained in a law books that are relevant.
Sir, can you repeat this?
Statements contained in a law book, whether
Yes,
those
sir.
are relevant.
I guess no, sir. They are not relevant. I'm
Okay. Uh, falsus in uno, falsus in omnibus. What does it mean?
false in one thing, false in everything. The maxim says it's false in one
Uh,
thing.
whether it has any applicability in
No, sir.
Indian Evidence Act?
No, sir. In Indian law, it is not applicable.
Okay. Just tell me, I went to the house of my friend, and there my friend stole a watch of mine. Okay, and then I have no other evidence against him. The only evidence that is there is his CCTV that is fixed in his house. So obviously he will not allow me the CCTV footages. So what I did was I went inside his house during the night and I stole the CCTV footage and I produced them as evidences in my case. Whether they may be used as evidence,
So they may be used as evidence, but here also he has done that thing by doing trespass by night.
but I'm asking whether it can be used as evidence.
So yes, it can be used as evidence.
Okay. Uh, what is the meaning of quick with child? Can you tell me what is the meaning of quick with child?
Yes, I'm unable to answer it.
Okay. What is the effect of fraud on limitation?
So it is defined under Section 17 of the Limitation Act. Uh, s- uh, till when the person upon whom the fraud is committed does not know the fact, the limitation does not start. And when the person knows that the fraud or misrepresentation has happened with him, from that time onwards, limitation starts running against him. And within 1 year from the date of from the commencement of the fraud, the person have to file a suit.
Okay. Right. Whether there is any exception to the rule that period of limitation once begins to run will not stop.
Yes, sir, there is an exception to this rule, and it is defined under Section 9. Sorry, sir, but there is an exception to there is a proviso under Section 9, says that when the estate of the deceased creditor is given, administration of estate is given to his own debtor. So that time the period of limitation can be stopped. And also, in cases of legal disability and also the period of limitation can be stopped. And initial period of limit sorry means it cannot be extended, but the uh, sir, I'm unable to explain it, but I know the answer. I'll go through it again.
Okay, I'm sure. Can you tell me what do you understand by nikah halala?
So nikah halala is a term where a person gives divorce to his wife, and after that he again wants to marry his wife. So that time the wife has gone through the iddat period. Then she'll marry another person. Then the person whom she married, that person will give divorce to the wife. Then again she will go through the iddat, and then she will marry her former husband. It is called nikah halala.
Yes, correct. Correct. Okay. Diksha, thank you. That will be your interview.
Thank you,
Now we'll
sir.
proceed to the feedback.
Yes,
As
sir.
I can clearly see, you need a little bit of more revision because you are able to go there but not able to explain because of lack of
Yes,
revision.
yes, sir.
Okay, that's all that you require. My job was to probably do it as soon as possible so that you will be awakened.
Yes,
Okay, now that you are awakened, I'm sure of whatever time we have, 10, 12 days, you will give it your best and revise as many times as possible. This is the sprint time. This is the last time where you have seen a race where racers are running a marathon. In the last phase, they sprint. So
yes,
don't think that this is the phase where I'll slow up and things will be fine. You have
yes,
to sprint. Okay, you have to do a sprint. Some questions that you could not answer. Yes, quick with child is related to abortion. It's related to abortion. Okay, and Hadya, Rad, all of these you'll read about it. You'll read about it. Hadya, Rad, all of these Muslim law, you read about it. Then you could not answer the child in conflict with law. That is defined in Juvenile Justice Act. A child who has committed any offense is called a child in conflict with law. Okay. Now, um, yes. What else? Law books. The statement contained in law books, whether they are relevant or not. Yes, they are relevant. It is given in Evidence Act. They are relevant. These are some of the questions that you could not answer. Please, I'll send you the interview, whatever you did, and you probably can see and relook the provision that you missed out. And within 4 or 5 days, we are meeting again. And please be prepared. Within 4 or 5 days, I expect that you'll do better that time. Okay,
okay.
4 days are
Thank you,
enough
sir.
to revise it at least once. Okay. So at least once or twice you revise everything. Quick revisions, quick revision as soon as possible. One act it should take you max 1 hour. 1 hour you revise. Then 1 hour again you revise. So each day you revise it. Then only all the things that you are going to say, your concept will be you'll be able to express better. Okay. That I know that you are knowing it. Just that you are not able to explain because of lack of
Yes, sir.
revision.
Yes.
Okay. So that's it. We'll meet soon in 4 5 days. Just one more thing about the way you give the interview is you seem to be in a bit of hurry. You are giving it very
Yes,
quickly.
sir, I'm a
That
bit
is maybe
nervous.
that is a bit, that is because of you're a bit nervous maybe. But that you have to please address that. As slow as you say, it will only help you. Why? Because they will be able to ask you less questions. Because
Okay,
you
sir.
gave answers so quickly, I could put 30 35 questions to you. Otherwise I couldn't have. You're getting it? So it will act in your favor. You say, you take a chill pill. You'll say, they ask, Rad, Rad, Rad. Yes, sir. And then you say, what is a Rad? In this pace, in this slow tone, wherever you are not in a hurry, you are not supposed to go anywhere. And it will make sure that your questions that will be asked, because they'll maximum give you 15 20 minutes, not more than that. So if you are able to like give answers so quickly within 1 minute, if you are able to give one answer, then you'll face 20 questions. If you take
Yes,
1.5 minute, 2 minutes, then you'll face 10 12 questions. So plan accordingly. Don't let them. And quick fire, rapid fire always makes us in trouble.
it will
So
fire
don't
back
do
on
that.
me. Yes.
Okay,
Thank you, sir.
you are creating a rapid fire for yourself. Don't do that.
Okay, sir.
Okay. We'll meet after 4 5 days, and I'm
Yes.
sure with the revision, with the lack of nervousness will be also there. So we'll see that you'll be doing better. Okay.
Okay, sir. Thank you, sir.
Thank you. Emma, enjoy.